United States versus Wulff. United States Court of Appeals for the Sixth Circuit, 1985. Milburn Circuit Judge. The United States appeals the judgment of the District Court dismissing an indictment that charged the defendant, Robert Wulff, with offering to sell migratory bird parts in violation of the Migratory Bird Treaty Act, MBTA 16 USC 703, because a felony conviction under the Act does not require proof of scienter, because the crime is not known to the common law, and because the felony penalty provision is severe and would result in irreparable damage to one's reputation. We affirm the decision of the District Court and declare the felony provision of the Act, 707b2, unconstitutional. On September 15, 1983, a federal grand jury returned a one-count indictment charging the defendant with selling migratory bird parts in violation of 16 USC 703 and 707b2. Section 707b2 provides as follows. B. Whoever in violation of sections 703 to 711 of this title shall 2. Sell, offer for sale, barter, or offer to barter any migratory bird shall be guilty of a felony and shall be fined not more than $2,000 or imprisoned not more than 2 years or both. The indictment was based on a sale made by the defendant to a special agent of the United States Fish and Wildlife Service of a necklace made of red-tailed hawk and great horned owl talons. Both birds are protected species under the Migratory Bird Treaty Act. The defendant filed a motion to dismiss indictment or enter order directing charge of misdemeanor, arguing that because Section 707b2 does not require guilty knowledge, imposition of a felony conviction would be a violation of due process. The court agreed and directed that if the defendant was convicted of a violation, he would be sentenced under the misdemeanor provision of the Act, rather than the felony provision. The court summarized the Morissette holding. The District Court also relied on the case of Holdridge v. United States 282 F 2D 302 8th Circuit 1960, where a federal criminal statute omits mention of intent and where it seems to involve what is basically a matter of policy, where the standard imposed is, under the circumstances, reasonable and adherence thereto properly expected of a person, where the penalty is relatively small, where conviction does not gravely besmirch, where the statutory crime is not taken over from the common law, and where congressional purpose is supporting, the statute can be construed as one not requiring criminal intent. The elimination of this element is then not violative of the Due Process Clause, ID at 310. Applying these legal precedents to the facts before it, the District Court noted that the felony statutory penalty involved in this case included a maximum sentence of 2 years imprisonment or a fine of $2,000 or both. The District Court felt that these were not relatively small penalties. The District Court further noted that a convicted felon loses right to vote, his right to sit on a jury, and his right to possess a gun, among other civil rights, for the rest of his life. Dilemmas similar to the one presented in this case have been resolved in the past by reading a requirement of scienter into the otherwise silent statute. However, this court has previously held that Congress did not intend for scienter to be an element of the offense under the MBTA. These cases are distinguishable in that convictions therein were under the misdemeanor penalty provision of the MBTA or other regulations promulgated thereunder. We are concerned with the construction of the felony provision of the MBTA. In our opinion, we cannot read a requirement of scienter into section 707b2 because the crime is not one known to the common law. An element of scienter can be read into an otherwise silent statute only where the crime is one borrowed from the common law. The question before us today is not whether scienter is an element of the offense or whether Congress made a rational choice in legislating a felony conviction for the commercialization of protected birds. Rather, we must decide whether the absence of a requirement that the government prove some degree of scienter violates the defendant's right to due process. Extrapolating from Holdridge, the proper test would appear to be as follows. The elimination of the element of criminal intent does not violate the due process clause, where 1. The penalty is relatively small, and 2. Where conviction does not gravely besmirch. Section 707b2 does not meet these criteria. We are of the opinion that in order for one to be convicted of a felony under the MBTA, a crime unknown to the common law which carries a substantial penalty, Congress must require the prosecution to prove the defendant acted with some degree of scienter. Otherwise, a person acting with a completely innocent state of mind could be subjected to a severe penalty and grave damage to his reputation. This, in our opinion, the Constitution does not allow.